Been spending most our lives living in a gangster's paradise. Been spending most our lives living in a gangster's paradise. Keep spending most our lives living in a gangster's paradise. Keep spending most our lives living in a gangster's paradise.
3, 2, 1, roll 5.
In the name of God, the compassionate, the merciful. Good evening, friends, and welcome to the third episode of Crime and Punishment. This is a legal podcast, not a political podcast, so please do not ban us from YouTube and SoundCloud. We love Big Brother on this show, and I'm sure every member of my audience does as well. We have absolutely no political opinions. This is 100% about the law. This is, in fact, the podcast for the Invictus Law Firm, PA, a criminal defense law firm in Orlando, Florida. And tonight we're going to start talking about Carl Schmitt. I'm going to be joined by Tiger Gin tonight again, and we are going to discuss natural law and the advent of legal positivism. And to introduce that, I want to talk about Carl Schmitt, though, because we were supposed to talk about that last week, and we didn't get the chance to. So I wanted to talk about the story of how I found Carl Schmitt, right? When I was in law school, there was an institute, still there, the International Human Rights Law Institute, right? And the International Human Rights Law Institute is exactly what you would think it is. It's a think tank in Chicago, and it's all about international law, international criminal law specifically. So I worked on things like human trafficking. I worked on things like the law of war. That's what I really got into, both in my fellowship and afterwards. So I worked there as a research assistant in large part for Professor Bassiuni. And Professor Bassiuni had just a massive corpus of work, right? So he would have students who would have to, and this is all professors, right, who would have to do the research, do some writing, etc., etc. So one day I'm working on this tract on the laws of war. So there's a huge legal issue as to, the status of, say, rebel fighters, the status of partisans, the status of freedom fighters or terrorists. Like, are they criminals, or do the laws of war apply to them? So I'm doing a research project on this for a paper that Professor Bassiuni is writing, and he quotes in there Thomas Hobbes. Everybody knows Thomas Hobbes is, of course, the author of Leviathan. He quotes Hobbes as saying that truth, not authority, makes law. And that can't possibly be right. That cannot be what Thomas Hobbes said, right? Would Thomas Hobbes really say that law is based on truth? Like, absolutely not. Everybody knows the Leviathan is about force. It had to be exactly backwards. So I went and tracked down the original Latin version from the 17th century of the Leviathan, and I went to that passage and found it actually is the exact opposite. Authority, not truth, makes law. Auctoritas non veritas facit legem. And as I was researching this, I came across this guy who was a Hobbesian legal theorist. Turns out he's probably, and certainly in my estimation, the most important legal philosopher of the 20th century, and that is Carl Schmitt. So, if you've not been introduced to Carl Schmitt, please let us introduce you to him. You should find his books. First one everybody reads is The Concept of the Political. That is where he comes up with his famous definition of what politics is. And if you heard my broadcasts before this podcast, the ones that are political, that we don't talk about anymore, I talked a lot about the distinction between friend and enemy. That is Schmitt's definition of the political. What we're going to talk about tonight is natural law. So Schmitt based a lot of what he did on older legal theorists, right? Whereas today we base everything on modern legal theorists. Schmitt would talk about Grotius, who you've never heard of him before. You never heard of Grotius. You've never heard of Pufendorf. All these guys from the Middle Ages, that came up with all our theories of international law. This is what Carl Schmitt based everything off of. And of course, he loved Hobbes. But tonight we're going to talk about natural law and the distinction between natural law and legal positivism. And then toward the end, we'll talk about some legal news. So with that, let me introduce our friend and colleague, Mr. Tiger, Jen. How's it going, Tiger?
Yo, going good.
Radical. So, why don't you go ahead and explain to everybody what exactly is natural law and why should we care about it?
So natural law is something that it should be instinctual to most people, and natural law theorists say it is instinctual to people. Not to kill, not to steal. Those are the two big ones. Self-defense is another one that they bring up. Protecting your children, caring for your children, things like that. And the natural law theorists, so there's natural law in philosophy, where philosophers, they discuss just what are our moral instincts, if any. Natural law in the field of law is it is said to be the source of what is deemed positive law, not to be confused with legal positivism, but positive law are the legal statutes, the written law codes. So natural law theorists, they say that these codes, these laws that we write, they must be based on and come from natural law. And they are to be interpreted in regards to natural law.
So how does one discover what the natural law is, I suppose is the question. Is this something that is specific to the Christian roots of European peoples, Western civilization, or is this something that can be discovered across all times and climes and groups?
If you ask a natural law theorist, they will say that any natural law is universal. I'm not as familiar as I would like to be with other countries' legal history, so I can't speak to what they say. But in Europe and in America, when judges and lawyers and legislators were trying to determine what natural law is, their two main sources were nature itself, look at what the animals do, and another source was the Bible. And they would specifically quote passages in the Bible. And if you look up these old natural law theories, it's quite impressive where they will get court procedure from Bible verses, from Bible passages. So one of my favorite ones is in Genesis 3, where after the fall of man and God walks in the garden, he asks Adam, "Where are you?" before pronouncing judgment on Adam and Eve. And the legal theorists, they would cite that passage for where we get our right to testify. They say that God himself, he asked, knowing full well everything that happened, because he's God, he knows everything, he still asked man to speak for himself before giving him a punishment.
And people used to argue this in court and say,
yes,
look, this says this in the Bible, Judge. Let my client testify. Because Adam was allowed to testify on his own behalf in the Garden of Eden.
Yeah, they would cite these passages in court, but they would do it the same way that lawyers today will bring support to their arguments. So in a courtroom today, you would do best to bring up as much support as possible for your argument. You will want to cite everything that you can. And it was the same thing back in the Middle Ages and clear up to about the Civil War in America, where lawyers, they would make natural law arguments, but they would also have case law supporting what they're saying, statutes supporting what they're saying. It was never in isolation. And judges too, they would cite natural law for what they're doing. There is one legal case that every law student is familiar with where a judge is making natural law arguments. And that is Pearson v. Post. That is usually the first property law case that you are taught in property law. And that is the one in, I want to say it was 18th century America, where, let me bring it up here. Yeah, 1802.
That was 19th century, buddy.
Yeah, sorry. Correcting myself. So, where you have a dispute over who owns the fox that a hunter tried to catch that ran onto land. And in making his judgment, the judge, he cites fera natura, which is saying that any animal that, wild animals, they are the property of whoever catches them first. And this comes out of the laws of nature.
Right.
Typically, natural law in regards to property was simply seen as if you have it, if you're using it, that is your property. And that's where we get so many property rights from. A lot of it comes from these old cases, these old theorists talking about what the laws of nature said in regards to property.
Yeah, and for those that do not have legal training, what he's talking about, basing it on cases. So we have in Anglo-American history this principle where we base things on precedent, right? So a case that came before yours that has the same facts as yours, the outcome should be the same. And that comes from the Norman invasion of England. So when William the Conqueror came in 1066 AD, they established this new monarchy, right? But instead of just changing all laws and saying, well, this is the Norman way of doing things, this is how we're going to do things, now the Vikings rule, they actually said, all right, you guys just keep things as you had them before we got here. And there were two kind of systems of law. There were the orders and decrees that would come from the royalty, of course, but then there was also the common law. And the common law was where, look, if this farmer had 3 pigs stolen and the price was whatever the price of 3 pigs would be, a pound? I don't know what ancient English money was like, but if 3 pigs were stolen and the guy had to pay £1 and, to make up for it, then the next case that came along where 3 pigs were stolen, that person would also have to pay £1. This was just how things were done, and so they based it on the case that came before, and that system of case precedent came over to America. So ideally, we would still be basing things on, what you're talking about. We'd be basing it on, well, this case in 1802 said X, Y, and Z, so we should base it off that. Problem is, we become so hyper-focused on all these facts and details that the case law that was true back in 1802 is absolutely inapplicable today because there are so many cases in the interim, in the intervening centuries now. That case from 1802 has been overturned 57 times, and you can't possibly go through and weave a thread to go through every single case in the interim. So it would be some kind of Alexander's sword to the Gordian knot to be saying, look, yeah, all these cases before, that's one thing. But let's look to the natural law. Let's look to how things actually are in the real world, in the natural order. How should we base our decisions on that? Now, why do we not do that anymore? What is this new philosophy of legal positivism or legal realism?
Yeah, you'll probably hear me say realism because that's what I'm familiar with. But the two theories, they're the two names are they're probably the same. But so this happened. So legal realism that came about later in America, and one of the big proponents of it was Oliver Wendell Holmes. And Oliver Wendell Holmes, he was not a Christian. He did not believe in Christian morality. He did not believe in objective morality at all. And this is not an opinion. This is something that he states factually in his own writings, that he did not believe there was any. Put simply, he did not believe there was such a thing as natural law, because natural law is objective morality. If nothing else, it's what everybody knows is right and wrong. And to back up a little bit too, one of the purposes of natural law theory is to say what the purpose of law is. And according to natural law, the purpose of law, what law exists for, what we're trying to do when we're writing these laws, is to bring society in accordance with the laws of nature and laws of God. Legal positivism is saying there is no objective morality. And if there is no objective morality, no natural law, then what is the purpose of law? Why does law exist? It quickly becomes to look out for number one, is what it is.
Well, not even just why does law exist, but what is it based on?
Right.
In natural law, it's based on a natural order in the universe that is discoverable by just men who are seeking the truth, right? In legal positivism, it's based on, at this point, the consensus of the people. The consensus of the people, which is a total myth. I mean, think what you want about there being a moral order in the universe. You can say that's a myth too. But do we really think that there is such a thing as a consensus of the people that is going to make law? Like, the entire concept is ridiculous. But that is exactly the legal philosophy that prevails in the whole world today. It's not even just the United States. It's not even just us in England or even Western civilization. It's the whole world. And the United Nations is based on the same legal philosophy, that everything is positivism. It's not a natural order. It's everybody in the world agrees that this Declaration of Human Rights is the right thing to do, right? And if you don't believe in it, you are living in a barbaric past, which is one of the things that Carl Schmitt pointed out when he was pointing out, the Kellogg-Briand Pact and all of these internationalist liberal attempts to outlaw war. He's saying, these guys are saying, we all agree, everybody agrees, at least those of us who are enlightened liberal democratic societies, we all believe and agree that war is a bad thing and should be outlawed. And anybody who transgresses that is a war criminal and should be prosecuted legally, because now we should have a world court, etc., and so on and so forth. So what he's pointing out is anyone who disagrees with that is now a barbarian who is a legitimate target for annihilation. And that is really what led to the world wars and this entire philosophy that, we all agree on this, and if you don't agree, you're not really human. And that's really the darkest end of legal positivism, that it's based on this consensus, this imaginary, totally bogus consensus that does not exist. And if you don't agree with it, you should be wiped off the face of the earth, you have no rights, etc. So, that being my rant, what are the more benign aspects of legal positivism?
Well, another thing that's characteristic of it is they do not believe in overarching legal principles that govern judicial decisions. Rather, the judge makes the law, is what they say. They say that the judge, they look at the non-legal facts of a case to determine the decision, as they look at economic, political, and social dimensions of a particular case. And now I will ask you, what does that sound like? Who does that remind you of? It's exactly what goes on with judges today, where they will decide a case just based on what they think society wants, rather than some overarching legal doctrine or natural law, divine order, or anything of the sort guiding their decision. Rather, it's what do the people want?
You're telling me that judges base things not necessarily on the law, but on public opinion? That can't be right. There's no way that's right. Not in this country.
Oh, no. Never.
Yeah,
they're impartial.
It used to be until, like 100 years ago, that, like you said, people would literally base things on the Bible. And
yes.
you think of that now, it's like, you would consider that insane. If I went into court and said, well, Your Honor, the Lord did say X, Y, and Z. So why don't you cut my client some slack or something? The judge would say, Mr. Invictus, that is not in the statute. What are you talking about? You would be absolutely thrown out of the courtroom for trying to argue natural law or the Bible or anything of the sort. Anything that is not in the statutes or in case precedent, it is absolutely not going to be considered by a court. Maybe I'm wrong. Maybe somebody.
I would say the closest you can get to it today is in a jury trial. You can certainly make what the rules of logic call appeals to nature. You certainly could do that. You can say, oh, of course, a mother would fight to protect her children. Every mother would fight to protect her children. Yeah. Everybody will fight to defend them. So you can make appeals to nature like that. That's the closest you can get to it today.
Yeah,
if you're just trying to kind of pull at the jury a bit. Maybe a judge, too, you can get away with it. But you can't go in and say, oh, the laws of nature dictate. You can't do that.
Yeah, well, it's probably better not to do that with a jury anyway. Yeah. You go in talking to the jury about Grotius and St. Augustine, and they're just gonna look at you like you got two heads.
Right.
So probably better we keep emotional argument. Oh, speaking of Augustine, though, that's one of the things I want to talk about with natural law. Certainly, you've heard the legal maxim lex injusta non est lex, right?
I probably read it and have no idea what it sounds like.
Well, it's Latin for an unjust law is not law.
Exactly. Yes.
So it is, that's St. Augustine. That is a concept as old as time. Well, at least as old as St. Augustine. And it's what a lot of our legal system is based off of. That if there was an unjust law, then it's not really law. And that it should be repealed or it should be rebelled against. It's a long-standing concept. What upsets me is when you look at something like the Stanford Philosophy website, and they're trying to say that St. Augustine and H.L.A. Hart are in the same boat. You said you did not study H.L.A. Hart at all in law school, right?
Correct. My legal education was very practical.
Well, good for you, because it's terrible. So, modern legal philosophy is based, I think it's fair to say, almost entirely on H.L.A. Hart and his students, Dworkin foremost among them. And these guys, they are part of that school that believes that this is all about consensus. And law works out as we go back and forth on the needs of people and on our, concepts of justice and whatever else. And, in the end, we come to some agreement. And that agreement, that contract is law. Like, it's ridiculous. I guess some people still believe in Rousseau, the social contract, like there's a noble savage and tabula rasa, and, it's really society that corrupts us. We have no inherent human nature. Like, people actually believe this stuff. They've believed it for hundreds of years. And so when you come to the modern era, you come to the 20th century, and you got people like H.L.A. Hart and Dworkin and all these people saying this, the legal philosophy class that I took in law school did not mention Carl Schmitt. The only time it mentioned John Austin was as a bad thing. John Austin formulated law as the if I can remember it exactly verbatim, it was the command of a sovereign backed by the threat of force. That is what law is, right? And that makes sense, but not according to these guys. So these dogs are barking now. I'm sure that's coming through the microphone.
Yes, it is.
So anyway, I will let you take it from there until these dogs start barking.
Sure. In my law school, the only time I ever heard of natural law was first when we were reading Pearson v. Post, but the professor didn't mention it. And the other time was in a civil procedure class, and it was actually in like the sidebar of a case book regarding the Erie Doctrine. I don't recall the details anymore, but one of the early jurisdiction cases that built on the Erie Doctrine apparently touched on natural law. In this case book, it described natural law as believing in some mystical higher laws, and like the judge's job was to try and figure out what it was using the words mystical, magical thinking, things like that.
So
it was very derogatory.
Slanted. No.
Yes, it was very derogatory.
Don't say.
And said no lawyer or judge or legal theorist believes this today, and that is just not true. There are legal philosophers and professors today, very few, but there are a few today writing books on natural law. They believe it and they try to practice it.
Yeah, imagine believing there's like some kind of order or some discoverable truth in this world that isn't just made up in Congress. I mean, that's crazy, right? So, God, you lucky dog. Never had to study H.L.A. Hart. Never had to study legal positivism. You lucky dog. Yeah, what? It's
well,
wild.
The way that law schools teach law is all in accordance with legal realism. All of it. They teach it.
100%.
But like they don't mention it. It's just that's just how they are. It's
the underlying assumption of all things. It's like being in public school, elementary school, you don't really have to. Well, all right, maybe in elementary school you're a little indoctrinated, but by the time you get to adulthood, you don't really have to say, well, we should have checks and balances. We should have, a government by the people and for the people. We should vote. You don't really have to say those things. Everybody knows those things. Everybody agrees on those things. It's like an underlying assumption of our entire society. So if you say something contrary to that or outside of that box, that's when people start looking at you weird. You don't really have to go around preaching to people, well, we've got, 3 branches of government for a reason. We've got a right to vote for a reason. Everybody thinks you have a right to vote. Like, who really goes around threatening democracy? It's just, it doesn't happen. It's happening now, for good or for ill, which we will not comment upon.
Well, speaking of rights, where do rights come from? It comes from natural law. When the founders were writing the Declaration of Independence and they were saying people have the right to life, liberty, they were speaking of natural law. That's where it all comes from. But now today, people, they want to call privileges rights. And in some cases, rights privileges. They don't even know what a right is. It's something that comes from natural law. It isn't something that's granted you by the government. That's a privilege, but they all say that, like the right to vote. That's something really more. Maybe some natural law theorist has that coming from natural law. I haven't seen it, but the way I understand voting is it's a privilege coming from the government. That's why, and maybe not anymore today, but supposedly an illegal immigrant would not be able to vote because it's a privilege granted to citizens.
Hey, live it in the past, man. Everybody has a right to vote. Everybody can vote in every election. Everybody knows that. But yeah, when you think about even the Constitution, the Bill of Rights recognizes there are inalienable rights. These are things that cannot be granted by government and cannot be taken away by government. It's an automatic appeal to natural law, saying that these are rights that everybody has no matter what the government says.
Yeah, and that's how the framers understood the Constitution, Bill of Rights, as they were writing it. They were understanding as declaring aspects of natural law into positive law, which is what you're supposed to be doing when you're writing laws, really. And I think that a good thing to make clear for the listeners too is that they might be hearing all of this about natural law and be thinking about things like, oh, what about like speed limits and bankruptcy laws and things like that. The natural law theorists, they would look at those, they called those municipal laws. Blackstone called them municipal laws, and others did. So those are laws written down purely for the convenience and functioning of the society and government. You still want to make sure they are in accordance with natural law, but they're not believed to be stemming from natural law.
Right. Yeah, I mean, how could you say that regulating the speed of an automobile that can go 200 miles per hour is somehow based in, the original natural order of the universe? Like, obviously, that would be ridiculous. You have to have some kind of legislation being that which is made law by groups of people or by a singular sovereign. So yeah, obviously there has to be, both sides of the fence there. But speaking of both sides of the fence, you want to talk about these articles we got. You've got Supreme Court's new deeply fractured decision on churches and the pandemic explained. So I guess Justice Barrett, the newly Catholic justice who is Catholic, gave her first opinion. So she was the writer of this opinion, right?
Yeah, she is. And for whatever reason, I could not find her opinion itself, only the concurrences and dissents. So, and even the article. So, I don't know what happened to it.
I'm
But
sure it'll come out in textbooks somewhere.
Yeah.
So, what exactly happened in the case then?
So this is one of the pandemic cases that have been coming up, and this one is from California, and it's regarding California's lockdown orders on the churches. And the churches are saying that their constitutional rights are being violated because they have to close down, but the secular businesses have to be open. And that's really it at its core. And somehow we get a four-way split on this opinion.
So let
again,
me talk
this
about.
is not...
Well, let me say preliminarily though, for the people who are not lawyers or law students. So a four-way split is pretty rare, I'd say. That's a big split. So the thing is, there are 9 justices, right? There's the Chief Justice, there's all the Associate Justices. They all either join an opinion or they write their own. So there's a majority opinion that one person writes. Everybody joins it. They can write a concurring opinion. A concurring opinion is where you basically agree with the majority opinion, but you have your own reasons or you want to state your own views in some other way. And a dissenting opinion is where you disagree with their reasoning or you disagree with their ruling and you write your own dissenting opinion saying, no, this is how it should be. And sometimes dissenting opinions are actually relied upon in future court cases by other justices who say, actually, the majority did have it wrong. This dissenting judge was right the entire time, and that's why, in large part, it's one of the many reasons that dissenting opinions are important. So a four-way split, what is that? Like, you have the majority opinion that they agree, you have a concurrent opinion that agrees on the grounds, you have opinions that are concurrence in part and dissent in part, and then you have a dissenting opinion. That's what I would imagine going on.
Yeah. And does it sound to you like these judges are basing their opinions on some overarching legal, moral principle at all?
God knows what they're basing it on.
I mean, clearly they are not. And if a court shouldn't look like this. This is not what judges are supposed to be doing. I don't think you would ever get something like this back in if there was back in the 16th century or anything like that in the Middle Ages where natural law was really hard pushed in Europe in the courts. They would be, rather this sounds like judges basing their opinions on what they think is what they want, what the society wants, things like that. It's literally their opinion. That's what we're looking at here. Opinions.
In the Middle Ages, they would all agree. There'd be one opinion. Put them in the Iron Maiden. So I'm imagining Amy Coney Barrett's opinion was that churches should be opened, right? 2-6. Oh, yeah, of course it was. Yeah, I remember. Okay. I'm back on the trolley now. Yeah, so it was an actual win for the churches in California,
yes.
Of all places. Yeah, so what was the summation of the opinion? We don't have to go into the text of the opinion itself, but what was the overall ruling here?
Well, like I said, I don't have the opinion. I feel like this article was published before the opinion was. So, but what I gather from the article and from the dissents and everything is that she did find the California's laws unconstitutional, which under constitutional law, it really should be, because they're based on, so the legal principle, the constitutional principle, is what's called strict scrutiny. And strict scrutiny is where the government needs to have, in order to make their law effective, in order to have the law pass constitutional muster, they must have a compelling reason, and this law must be narrowly tailored for its purpose. So what that means is it must be the least restrictive on people's autonomy or rights or whatever it is. It's a compelling interest, narrowly tailored law that doesn't interfere with people's lives too much, is what strict scrutiny is, and it's considered a high standard, the highest standard, in fact, and it's hard to beat.
So, not interfering with people's lives too much, banning them from going to church probably doesn't fall under that. That seems so extreme that it's unthinkable. Until it happened. It actually happened in America. Of all places, it happened in America. It's like, it's unbelievable. I was in jail while this was all going on, but even in jail I was thinking, people were going to church during the Black Plague. Like, if the churches stayed open during the Black Death, why in God's name would they not stay open during COVID? I guess that's that probably sounds like a right-wing maniac's opinion. But now, the Supreme Court apparently agrees. My favorite part of this article from Vox, of all places, it says, additionally, the state bans indoor singing and chanting. It bans indoor singing and chanting because, in the words of one of the state's expert witnesses, quote, most scientists believe that group singing, particularly when engaged in while in close proximity to others in an enclosed space, carries a high risk of spreading COVID-19 virus to the emission of infected droplets, end quote. That is enough to shut down the most central right in America. It's wild. It's wild, man.
It really is. And this is a legal podcast. Getting back to the legal thing, the reason why the article mentions about the indoor singing is because these concurrences and dissents, they are all somehow disagreeing over the fact that, remember, this is California. So this is where the movies are made. There's singing in movies. When they're making these movies, they're singing. And so these justices, Gorsuch in particular, he notes, okay, so it's okay for some actors to be on a stage singing, but it's not okay for people in the choirs to sing. And this isn't some internet argument double standard. This is actual well-written constitutional law, where when you're looking at whenever the law is placing restrictions on freedom of worship, they have to see whether or not the law is written in a neutral manner, whether or not it's applying to secular as well as religious institutions. So, as the article notes, there's been plenty of cases of these virus cases that came to the Supreme Court, but they were in regards to a neutral law that was banning practices in both religious and secular institutions and businesses. And those cases brought by churches, they would not win because the law was neutral. It was applying to everybody in the same manner. But here in California, it's clearly there's some kind of favoritism towards the movie business that the justices are seeing here. And that's why they ruled the way they did.
You're telling me that the government of California showed favoritism to the movie business over churches? Pull the other one. That could never happen. Well, this guy has a legitimate point here. He to my pointing out that people were going to church in the Black Death, and why can't they go during COVID? Rituale Romanum says they had military power during the Black Death. That's true. Yeah, there's a lot more on the line if you didn't go to church back then, I suppose. Fair point, my man. So, yeah, well, this is a win, I guess. However messy it is and all over the place. What's the other? Court won't allow Alabama execution without a pastor. This is on SCOTUS blog. So why don't you tell us about that ruling there?
Okay, so this one is about a man named Willie Smith he murdered somebody and faces the death penalty. He was to be executed. And this was in the state of Alabama under the 11th Circuit. And what happened was he was requesting to have a Christian pastor there with him when he was executed, give him like his final rites or penance or whatever, what have you. And so what happened was there's a bit of a history to this where Alabama, they used to allow priests and clergy in at the execution site when the execution happened to be there with the person to give him his last rites. And somewhere along the way, somebody wanted a Buddhist priest to be with them. And Alabama law at the time did not allow for that. They were like, no, it's got to be Christian and I think maybe Muslim or probably Jewish was the other one. It was like, it was only two religions that they were allowing. And the Supreme Court said, that's discriminating against religious rights. You got to allow all of them or you got to allow none of them. And Alabama decided we're not allowing any of them. And this is where strict scrutiny comes in again. Once this case came by, that the justices, they applied strict scrutiny, and they said the court has to have a compelling reason to not allow clergy in at the execution. And it must be a narrowly tailored one. Obviously, they have the state, they do have a compelling interest, supposedly, in not allowing certain people at executions. They cite security. So, okay, that's a compelling reason under legal doctrine. But is it narrowly tailored, where they're making a blanket ban on it? The justices were saying no. And there were a few saying it wasn't even a compelling reason, because some states they would allow other states will allow clergy, though some will allow family members to be there and things like that. So I found it an interesting case, especially since, as I said in the last episode, these state and federal executions, they're rolling along now. They were very rare before, but as this opinion states, there's been 10 in the past year already.
Do you know what their reason was for trying to keep him out? Just that were they saying he was unnecessary? Like a pastor's unnecessary to be there? Or, because I don't see anything about a security concern for this pastor.
It wasn't for an individual pastor. So the law was in Alabama was, we're not allowing any religious clergy in at the execution at all. And the state's reason was security. It's a prison. We can't just have these people coming in. And in the opinion, it looks like the lawyers the way they tried to defend that was by citing 2 instances where family members were at an execution caused a disruption. And as the court said, they're like, but that's family members, not clergy that could be screened by the prison or jail. And, you can bring in your own clergy that you're familiar with. It doesn't have to be like the guy's personal home pastor or something. So that's what that was. It was a faux call for security concerns. I mean, as I said, like under the legal doctrine compelling interest, you can say security is a good reason, but in this instance, looking at the facts here, it doesn't seem a good reason.
Well, yeah. What are you going to do? I can tell you there's a lot of restriction in jails and prisons that you wouldn't really imagine exist. You were talking about how there was an issue here about they were only allowing like 2 religions. So they just decided, well, if we can't just allow these 2, we got to allow everybody. We're just going to allow nobody. And I've seen that, in the jail, in the jails, multiple. You get a quote unquote religious diet in the Orange County jail that is not kosher. It's a vegetarian diet. Like that's all there is to it. There's no difference between a Hindu diet and a Muslim diet. Well, the Muslim diet would be kosher, but no difference between a Hindu diet and a Buddhist diet and a whatever else. It's all just, well, you want a religious diet? Vegetarian. Here's 6 slices of cheese and some lettuce, you a-hole. That's just how it is. And you go to a place like York County, South Carolina, and you get kosher, buddy. It's either kosher or you're on the regular tray. How is that legal? I don't know. I guess because poor people can't challenge it. I don't know. You remember when the Capitol guy, the shaman from the Capitol riots or whatever,
the guy with the horns on?
Yeah, saying he's a shaman and he had a religious diet, and a federal judge actually said, yes, this man must eat nothing but organic food. I was like, how did he do that? Maybe because it's a federal judge, I don't know, man. But in state court, you'll be laughed out of court talking about a religious diet. Yeah, unless you're going to have a kosher diet or vegetarian. I don't know how that's legal. I guess because just no one fights for it,
It probably is. You don't fight for your rights and, you don't get them.
Yeah, that's one thing I've told people for a long time. You want to go do these things. You want to be an activist. You want to fight for your rights. Well, one day you're going to get arrested, and you have to decide, are you going to fight for it, or are you going to just let it happen? Are you just going to be like, all right, well, that's as far as I'm going. It's time to walk away now. Everybody's got to make that decision for themselves, but you got to know going in, you're going to get jammed up. So you've got to understand when you go into something like that, whether it's, environmentalist activism or it's, I don't know, what other causes are people doing? Animal rights activism. You have to understand that you have no rights unless you go to court and fight for them and make them rights. Like, the entire point of the Constitution and Bill of Rights is the government will take these things away. You have to fight for them. If you don't fight for them, they're already gone. So, we are out of time, it appears. Do you have any closing thoughts for the hour, Tiger?
I don't, nothing in particular. I think I already gave my rants throughout the show.
All right. Well, we've got, first of all, what's up, everybody in the chat? I have not been responding to the chat because it's just been a bunch of arguments. People getting timed out, people getting deleted, people getting removed. What is going on here?
I'm glad I can't see it. I'm glad I can't see the chat.
It's distracting today. a lot of it is just absolutely not what we are talking about. It's clearly a lot of provocateurs have come into the chat, so what are you going to do? But to everybody who's not one of the provocateurs, what's up, everybody? I was supposed to be on Stryker this past Friday. He was, in fact, sick. I can confirm that. So I will be on the People's Square this Friday at 9 p.m. Eastern. So we'll talk about that then. So anyway, Tiger, thank you very much for joining me. And we'll see you next week, man. And everybody in the chat there, thank you for coming. Thank you for listening. And let me find this awesome outro that my friend suggested. You know who you are. Good night, everybody.
Take a look at my life and realize there's nothing left. 'Cause I've been blasting and laughing so long that everyone thinks my mind is gone. But I never crossed a man that didn't deserve it. To be treated like a punk, you know that's unheard of. You better watch how you're talking and the way you're walking, 'cause this life will only leave you lined in chalk. Been spending most of life living in the gangster's paradise. Been spending most of life situation that got me facing. I can't live a normal life. I was raised by the stripes, so I gotta be down with the hood team. This television watching got me chasing. Death ain't nothing but a heartbeat away from living life to a die.